Hello, and welcome to Mean Street News. Mean Street News is here to provide accurate news to help citizens affect change in their local government and beyond. Being nice is overrated. It is time to be real. I mean what I say, and I say what I mean. The time to step up and step in is now. So please come join me, Katie, over on Mean Street News to discuss Ohio politics and beyond. I hope to see you there. Hey everybody, good evening, good evening. Did you miss me? It's been forever. I bet. So good evening, Mean Street News. Good evening, Lorain County. Good evening, Ohio. Thank you if you guys are going to be joining me tonight. I was going to conclude we'll just finish 2024 and conclude our investigation. However, based on some data I received, hold on, fix this light because it's drowning me out. Here we go. Okay. Based on some data, based on a document that I literally received in the mail today, went out and checked my mail, I saw a nice brown manila envelope and opened it and started reading and was very surprised at what I received. It is a letter from Lorain County Prosecutor's Office, J.D. Tomlinson, and it is a letter to Sheriff Phil Stammitti, dated April 4th of 2024. Hold on, I gotta turn my... Okay. So April 4th, 2024. So what I'm gonna do is, so since I received this and I want the public and the taxpayers of Lorain County to hear this, I decided tonight I'm just gonna read the letter. I might make some comments here and there, just about basic background information. Yeah, so we're just gonna do some reading this evening, and then I really want your guys' opinions on what you think, especially if you've listened to the last couple episodes. And yeah, I'm very grateful to whoever sent me this, to whoever who sent me this document. I just wanted to say real quickly before I get into it that I appreciate it. I know sometimes it's hard for people to come forward with their actual identity, and if anybody ever wants to just drop me off a packet of documents in the mail, thank you. I'm very grateful for that, and I'm happy to accept them, especially if it's sourced and all of that. This light is driving me crazy. Here, a little bit. I gotta do this. All right. So we're just going to do some reading tonight, and I'm just going to start, okay? So again, this is April 4th of 2024, and it says, regarding your letter on March 29th of 2024. And just to give you why you should stick around, I'm not just going to be boring, is, they talk about Battistelli in this document. They talk about Detective Vansant with the Sheriff's Department and his investigation into the prosecutor himself, and then regarding the Battistelli investigation and accusations made by him. And JD actually went over those in great detail, and also ends with some information about Mr. Tony Cillo, who I mentioned is the person running against JD Tomlinson as a Republican. However, he's not a Republican. He is a Democrat, and we showed you his voting record. And for those who are new, I'm going to really quickly, and I know I'm jumping, but I just still can't believe I got this today. And here's Mr. Cillo's record. He pulled a Republican ticket in the primary of May 2nd of 2023. So this guy in the X, now I know what the X means. It means you don't get to know how people voted during the general election here in Ohio. So, but I can only assume he didn't vote for Donald Trump in 2016 or 2020. And when I say never Trumper, I don't really care if you, not that I don't care, I think you should vote for Donald Trump because I think Kamala is a communist, and we will see the destruction of that office with her. She's just evil. But it's your right to vote for whoever you want to. But when I say never a Trumper, it means like this guy has been a Democrat his entire life up until 2023. And then he decides he wants to run against our county prosecutor of the same party affiliation. And because he doesn't think he's going to win his party's nomination or get support from his party, he decides to then run as a Republican. And, shame on us that we didn't, as Republicans, our central committee. I know we have a new central committee chair who is Bob Mylander. It used to be Mr. David Arredondo, and he was unseated this year. So hopefully, I know Bob is going to make some changes and we won't allow this to happen again. But we talk about Mr. Stammitti, and I'm just going to sip on my tea and I'm just going to read, okay? Stop talking your ear off. It's late. We all want to get to bed. Okay. So I'm JD Vance right now. Not JD Vance, sorry. JD Tomlinson. Dear Sheriff Stammitti, I believe you are mistaken about a few facts and about what constitutes sufficient cause to seek a special prosecutor. For example, when Captain Robert Vansant, I always think Lieutenant, Captain Robert Vansant requested that I seek a special prosecutor to conduct a grand jury investigation of the facts surrounding the CCI Motorola contracts, he claimed to be aware of facts that would justify the appointment, in parentheses, including the cost, of a special prosecutor. However, in order to make such a request prudently, I must present a fellow county prosecutor or state officer, the Attorney General, state auditor, with an investigative report that would give rise to a reasonable suspicion, not quite probable cause, in parentheses, but that criminal offense has been or is being committed. Because Captain Vansant has either unable or unwilling to provide me with a report of the facts that he has gathered in support of his request for a special prosecutor, I have been unable to persuade anyone to take up this cause. If I am not aware of any reason to seek the appointment of a special prosecutor, I cannot imagine why doing so would be good government. I hope that the foregoing answers your questions with regard to requesting a special prosecutor. I would agree with you, however, that the occasion could present itself when there exists not only a reasonable suspicion of criminal activity, but also a conflict of interest on my part that would suggest the need for a special prosecutor. So far, I have not been presented with that occasion. In your March 29th, 2024 letter, which I records requested this evening, so when I get that, I'll read it. You claim to have information that requires my application to the Commonplace Court, I think I do have it, for its appointment of a special prosecutor, independent of me, to investigate my office. You claim that your office is in possession of information indicating the conduct to be investigated is within the prosecuting attorney's office. You have attempted to provide examples. 1. My office did facilitate the sealing of a felony record in the circumstances where the conviction included an offense charged under RC 4511.19 and was not sealable under Ohio Revised Code 2953.32. The facts of the case supported this extraordinary remedy. In this case, the defendant, Julie Schlepsiak. I'm just going to say Julie C. because I feel like I'm going to butcher that name, and I should have probably Googled it, how to pronounce it before I came on, but I didn't. Julie C. was drug dependent when she was stopped for a traffic violation. Suspecting that the defendant was under the influence of some intoxicating substance, a citation for OMVI was issued, together with complaints for other offenses, including felony drug abuse. In resolving the case, the defendant pled guilty to the indictment, including the OMVI. Because the OMVI could not be sealed, the record of the drug conviction could not be sealed. Due to her record of drug abuse convictions, in parentheses felonies, Miss C. Schlepsiak, I can't do it, I gotta do C. Miss C. was thereafter never able to obtain employment in any meaningful capacity, notwithstanding having earned a baccalaureate degree. In order to seek gainful employment, Mrs. C. retained attorney Michael Camera to follow a motion for the sealing of a record of conviction under ORC, Ohio Revised Code 2953.32. At the same time, attorney Camera, recognizing the difficulty caused by the OMVI conviction, contacted my chief of staff, Jim Burge, to see if there might be an avenue of relief. While I was unaware of attorney Camera's motion to seal at the time of the filing, I was able to discuss the matter with Chief of Staff Burge upon receipt of your March 29th, 2024 letter. So he wasn't aware of this motion to seal. His chief of staff was, though. He advised me that the procedure to follow in the above circumstance involves the application of Criminal Rule 57B. Criminal Rule 57 provides in part as follows. If no procedure is specifically prescribed by rule, the court may proceed in any lawful manner not inconsistent with these rules of criminal procedure, and shall look to the rules of civil procedure and to applicable law if no rule of criminal procedure exists. According to Jim Burge, Civil Rule 60 is the civil rule that is the avenue of relief. Civil Rule 60 provides in part that B, on motion and upon such terms as are just, the court may relieve a party or his legal representative from a final judgment order or proceeding for the following reasons. Four, it is no longer equitable that the judgment should have a prospective application. Clearly, the collateral sanctions visited upon the defendants that were caused by the unsealable misdemeanor OVI conviction being joined with the sealable felony drug convictions created a circumstance wherein the prospective application of the judgment could no longer be deemed equitable or fair. Indeed, it would be intellectually dishonest to assert that the legislator intended the collateral sanction of the perpetual underemployment to be the consequence of an OMBI conviction. This is because a simple plea to an OMBI charge at the municipal court stage of the proceedings could have obviated these collateral consequences. So that legalese is saying pretty much this woman who got the charge cannot be employed where she's employed and cannot do her duties as a business owner, a family, works in a family business, but a business owner with this OVI conviction. And yes, she was guilty of it, but he doesn't believe the legislator in writing the law meant if you get, this one conviction that you pled guilty to, it shouldn't ruin your life. It shouldn't cause you to never be able to work where you've invested your, time, money. And this woman didn't just go up to the prosecutor's office. She hired an attorney. The attorney, got a hold of the prosecutor and they did their prosecutorial stuff. And they're basically saying yes, she was convicted of this crime. Okay. But we're not trying to ruin the woman's life by, this conviction, nor is the legislator, when they wrote the law, is trying to do that either. So we're moving to seal her record so she can continue her employment. Now, does the family is a bondsman, and I don't think that really has much to do with getting this record sealed, but she can't do her job as a bail bondsman who's been in this community family's been in this community for over 70 years with a conviction on her record. And like he said, she got a bachelor's degree. She is working towards a better life. And especially, being in the age that we're in with the, oxy epidemic, heroin epidemic, now fentanyl epidemic, and it's been occurring since almost 20 years now. I can really think of, because it started back in 2002, 2004. We have to have some leniency with people. We can't just punitively punish people and be like, your life's over. You can't. You're never going to be able to find a job in the trade that you have mastered and crafted over this long. That's just wrong. So I agree with them. The Ohio Supreme Court has recognized the foregoing principle in State v. Shield 117, Ohio Standard 3rd of 2007, pages 7 through 10. This same principle was affirmed by a unanimous 11th Appellate District in State v. Hill 2023, Ohio 4486, 11th District, Trumbull County 2023, 51 through 57. In each of these cases, the courts were clear that Civil Rule 60 may provide a remedy to a criminal defendant when the criminal rules do not. In State v. Schlee, the Ohio Supreme Court made its ruling clear. Quote, today, we hold that the plain language of Criminal R 57B permits a trial court in a criminal case to look at the rules of civil procedure when no applicable rule of criminal procedure exists. Schlee, Supra 10. I don't know what super means, but 10. I look that up. It is important to note that the Ohio legislature is currently attempting to provide for the sealing of a record in cases where charges connected to the OMBI conviction are dismissed pursuant to the completion of intervention in lieu of conviction protocol, ORC 2951.041. See Senate Bill 197, which I did look up, and they are completely right about what they're about to say. Had this procedure been codified at the time, the instant defendant was in court, intervention could have been granted and the felony offense is sealed without resort to criminal R57B and civil rule 60. So he's saying if this legislation was actually passed by the General Assembly, this defendant could get her record sealed. And she can't get her drug record sealed. It wasn't really about the OMBI. It was about this drug offense. She couldn't get sealed because of the OMBI. So there's extenuating circumstances. It would ruin her life. People deserve a second chance. Even thirds and fourth chances. People deserve to live. The foregoing action taken by my office was the proper course of action given the defendant's circumstances. It was supported by the criminal and civil rules, and I would consider it in the future given similar circumstances. Hence, it is incorrect to say that there was no legal basis for the action taken to seal Julie C.'s convictions. You are correct, and a contribution was made to my campaign by Miss C.'s father. However, at the time the contribution was made, I was not aware that Miss C.'s felony convictions had been sealed. The allegation in part 2 of your letter that I made an offer to seal a criminal record in exchange for sex is ludicrous. Prior to my election, I briefly dated Ember Cornier, which we're going to call her Ember K, because that's from probably butchering their names. I should have looked them up. The person you reference and who had a record of conviction that she wanted to have sealed. I knew the nature of the conviction, but was not sure if the conviction is sealable. I advised Ember to talk to attorney Matt Mishak, who had represented her in the principal case. I did, in fact, communicate with Ember after I was elected, but I do not recall that we resumed seeing one another after I took office. After Ember was interviewed by someone from your office, talking about when she was interviewed by somebody from the sheriff's office, we exchanged the text messages that are attached here too as Exhibit A. The relevant portions of those messages are set forth below. All right, so he did send. I'm going to show you the document that was attached to this. Ember Nicole, he sent all of them. I'm going to read the relevant ones. I'm going to read the relevant ones, but he did send, there's a few pages of all of them, and I will publish this for you guys to view as well. I'm going to upload it after I get off of here. September 26th of 2023. Ember K. Sorry, I owe you a huge apology. I wouldn't cooperate. JD Tomlinson. Hi, Ember. What do you mean? Ember K. For them trying to interview me. I tried to text you, but it won't go through for months now. I work nights and I don't have access to TikTok in the plant. You can text me if you want or unblock me. September 29th, 2023. JD Tomlinson. So 3 days later. Ember, with all due respect, I have no idea why someone would want to interview you about me. I've done nothing wrong. I can't worry about things I can't control. I have too many other things to worry about. Ember K. Understandable. They heard a bogus rumor, apparently. JD Tomlinson. I can't do anything about bogus rumors, you know. Ember K. Yep. That's why I told them I'm not the one. We became friends. That's it. Any other questions? They, which I would like to know, they didn't like that. I hope you're well. JD Tomlinson. I hope you're well too. Parentheses. Emphasis supplied. Ember K. Would be nice to see you. Please note that Miss Corner's language would dispel the notion that our relationship was based upon a quid pro quo in any respect. The facts presented do not implicate evidence R 404B or the violation of any criminal statute. 3. In Part 3 of your March 29th, 2024 letter, you fail to present any facts that would raise even a reasonable suspicion of criminal conduct on the part of anyone. Jennifer Battistelli's attorney made claims on her behalf for a violation of Ms. Battistelli's civil rights. Most disturbing was the claim that the prosecutor's office had retaliated against Ms. Battistelli for claiming that another employee in the office had been subjugated to invidious workplace discrimination. The following are facts of the matter. In July of 2023, our chief investigator and victim advocate supervisor, supervisor, filed a formal complaint against Ms. Battistelli. The complaint arose from Ms. Battistelli's claim to the Civil Division Chief Dan Petticord and he's running for judge, by the way, common pleas, that the supervisor was treating one of the victim advocates, a female of Hispanic heritage, in a discriminatory fashion. And Battistelli's belief is that the advocate's race or ethnicity was an issue in the matter. Ms. Battistelli claimed that the victim advocate had complained to her that the 6 victim advocates employed by the office, 5 of them had their workstations in one office, and she, the advocate, was excluded from that office by her supervisor, even though space was available to accommodate her. I asked Chief of Staff Jim Burge and Deputy Chief of Staff Rich Resendez, who's running for County Sheriff as well, against Jack Hall's running in that race as well. Current Sheriff, who this letter is to, Stammitti, is retiring. So I asked Chief of Staff Jim Burge and Deputy Chief of Staff Rich Resendez to investigate the supervisor's complaint against Ms. Battistelli. To be certain, we would not countenance any type of discrimination in the office, especially involving a member of more than one protected class, Hispanic female, in parentheses. After the affected employee was interviewed, it was concluded that although the employee felt she had been treated differently from the other victim advocates in the office, it was not because of her ethnicity or her gender. Rather, having the affected employee work next to the retiring victim's advocate who was training her and whose workstation was outside the victim advocate office made more sense logistically. Because Ms. Battistelli's discrimination claim against the supervisor was found by Jim Burge to lack merit, Ms. Battistelli was cautioned in writing, and a letter of discipline was made permanent part of her employee file, which I don't know why I never requested. I requested her employee file today. So hopefully I'll get that from the prosecutor's office sooner than later. If not, I'll go up there. When I refused to intervene in the matter on Ms. Battistelli's behalf, she resigned. We subsequently received an oral communication from Ms. Battistelli's lawyer asserting a claim of retaliation against Ms. Battistelli. I hate this. I'm going to call her Miss B for right now. Stating her retaliation claim, Ms. Battistelli's counsel asserted that Battistelli had been disciplined for alleging discrimination against the above-described victim advocate. In brief, the claim was that not only had the prosecutor's office violated Ms. Battistelli's civil rights, but that we had also violated the public policy which encourages employees like Ms. Battistelli to report discrimination in the workplace. Upon the advice of counsel, we rejected the demand of Battistelli's attorney for the compensation in the amount of $150,000. And we finally agreed to settle the retaliation claim for $100,000. This sum is currently being offset as I have assigned all duties of the community outreach coordinator to other employees, which was Jennifer Battistelli's job. The assignment has been successful, though additional personnel are required. It is important to note that the foregoing decision to settle the Battistelli matter was made by me. And when he says by me, he means by J.D. Tomlinson. He is the one that made the decision with the settlement with his attorney, which I'm about to say, Dan Petticord, who's running for judge, acted in his capacity as my attorney. The commissioners relied on my analysis as an appointing authority when they approved the settlement. The commissioners relied on my analysis as the appointing authority when they approved the settlement. So it was the prosecutor's funds to pay out this settlement. It was his budget that this money was coming out of. It was his responsibility to cover that deficit. However, the commissioners in this aspect were just literally the fiduciary, okay, we'll approve that for your budget, pay out for your budget. It wasn't some conspiracy. I settled the matter with Jennifer Battistelli without referring the matter to Corsa for several reasons. I was advised that because Battistelli was alleging intentional conduct on the part of another office employee, Corsa may refuse to pay any judgment rendered or any offer or settlement made, which means if there was a settlement or offer, it would come out of county funds, it would come out of the prosecutor's funds, it wouldn't be covered by insurance, it wouldn't be a appropriate insurance claim. Taking the foregoing into account, together with the fact that Ms. Battistelli's claim accused the prosecutor's office of invidious workplace discrimination and would become part of our insurance claims experience, which is increasing the premiums, I elected to avoid the costly litigation, which it would have been, that would have ensued and settled the matter. I believe anyone in our office would confirm that the issues of diversity, equity, and inclusion are important to us, and that this civil rights claim caused me substantial embarrassment, which I think is the whole point of Jennifer, was to do exactly what she's doing right now. For both the prosecutor's office and the taxpayer, I believe that I made the right decision. So look what he said. For the prosecutor's office and the taxpayers, because he's actually saying I care about how we allocate the taxpayers' resources. I believe that I made the right decision. 4. In part 4 of your letter, you claim that in the course of settling the above matter, false representations were made by the prosecutor's office employees regarding the nature of the substance of the Battistelli claim, the responsible party, and the alleged misconduct. This allegation is untrue. The Battistelli page says 10. Hold on, stuck doing this week stuck together. Oh no, I keep doing this. 10. Sorry. 11. Here we go. So let me restart that. This allegation is untrue. The Battistelli claim was set forth to the county commissioners as outlined in part 3 above. Additionally, the assertion that I would have been personally liable for an intentional tort committed by one of my employees is clearly mistaken. Before I get too much further into my response to your March 29th letter, I would like to share with you some evidence that has come my way since you began conducting an investigation of my office and me. Captain Robert Vansant. Captain Vansant has been quite active, not only on your behalf, but upon his behalf as well. Most conspicuous has been Vansant's relentless pursuit of Jennifer Battistelli. Vansant has called and texted her relentlessly in an effort to recruit her as a witness against me and for his cause. Had he not fallen in love with her, maybe his effort would not have gone so wrong. In the above regard, I have been able to read some of the text messages Vansant has sent to Miss Battistelli. Examples include statements of his fondness for her and his disgust for me. Other examples include Vansant's request that she send nude photographs of her to him, and that she arranged to meet with him at his house when his wife Betsy was away. Most recently, Vansant began to stalk Miss Battistelli's former hairdresser, Alicia Quinn. desperately attempting to persuade her to say something about me that would corroborate his ill-conceived notion that I abuse women in general, and Jennifer Battistelli in particular. Vansant's pursuit of Alicia Quinn was solely for the purpose of attempting to wrestle away some fictitious tale of infamy regarding my treatment of women. The pages stick together, so I'm sorry. I have actually witnessed a ring cam recording of Vansant with two other persons that Vansant claimed to be FBI agents standing on Alicia Quinn's porch and threatening to bring her before the federal grand jury if she refused to speak with them. After this confrontation, I was contacted by Miss Battistelli and asked for some avenue of relief. We contacted the local police. I am giving a strong measure of consideration to issue a duces I can't say that word, tecum, I'm probably saying that wrong, subpoena for Vansant's personal and county issued cell phones in order to corroborate what I have actually seen and have described to you in this letter. I'm wondering if you did it. Strong measure of consideration to issuing a subpoena for Vansant's personal and county issued cell phones in order to corroborate what I have actually seen and have described to you in this letter. As far as Jennifer Battistelli's relationship with me is concerned, I will share with you the actual facts. Its Exhibit B contains text messages from Miss Battistelli to my mother that were exchanged months after she left my office. Here are some examples. Now we're going to read the examples, but first I want to show you. He then provided the actual text, which is, see, and there's a few pages. Okay. And like I said, I'll post those later. All right, so here's the ones he shared in his letter, though. January 12th, 2000. January 12th, 2024. Jennifer Battistelli. He has to dig deep, find out what makes him really happy, and have a safe home life he can come home to. He is so good, honest, and loyal. He should marry me. LOL. I am kidding. I can't get married for another 4 years with spousal support. So, emphasis supplied, she wrote, which is something I'm thinking she stole from JD since he put that in his letter, which I think is funny. January 12th, 2024. Again, Jennifer Battistelli. Marie, I have to say, you're one special woman. You are a person someone can trust. You hold no judgment ever, and you're quick to forgive. I admire the woman you are, and what a great mother you are. I know sometimes I fail when it comes to JD. I just don't know how to navigate some of the stuff that goes on. My intentions are pure. Thank you for being a friend. February 7th, 2024. Jennifer Battistelli. He's doing really good today. Explanation. We got to spend some time and talk. I think things are taking a turn. I wish everything was different. But even though things are super hard, this may just be our journey. We are all strong as hell, and I will protect him, you, no matter what. They are not stronger than us, and we have the truth on our side, which is why I'm giving the 60-second recording to the paper. She didn't say that part. It was me. Sorry. Anyways, the following text messages exchanged between Jennifer Battistelli and me would also dispel Vansant's unsupported belief that my relationship with Miss Battistelli was characterized as exploitation and abuse. These text messages attached hereto as Exhibit C. January 29th of 2024. Thanks for trying to pick me up. I'm sorry if I'm a bummer. Jennifer Battistelli. You're welcome. I just want to get through this as painless as possible for both of us so we can just go on with our lives. You deserve to be happy and free and win this next election. And I'm going to try to fuck that up secretly. And then she writes quotations, emphasis supply. But, you know, her focus was this next election. You know, I just want you to win, babe. And while I want you to win, I'm gonna, you know, release these secret recordings that I have of us. And I'm just gonna release 60-second little blurbs so I can portray this man as violent and abusive against me, the victim. And I'm never gonna, you know, answer anybody else except just David O'Brien with the Chronicle Telegram. I'm just gonna give him to him because he's so trustworthy. Is no political purpose whatsoever. Anyways, clearly Vansant's efforts to charm Jennifer Battistelli have been misguided. 5. Part 5 of your letter alleges that my office caused 2 other former employees to receive settlement payments that were contrary to law, and their settlement constituted a misappropriation of government funds. In truth, the settlement payments made to former employees Nicole Janik and Jennifer Scott were entirely in accordance with law. Please be informed that after the county commissioners approve a request for payment, it falls upon the budget director and the auditor to manage the details of the payment. The prosecutor's office is not involved. You can be confident that these officials have not misappropriated government funds. But Michelle did. Anyways, did I say that out loud? But Michelle did. Michelle did, yeah. 6. In part 6 of your letter, you allege that I employed 1 or more employees who were paid full-time salaries but were not required to work full-time. The only employee that comes to mind when these facts are alleged is Tony Cillo, the guy that's Democrat running as Republican for county prosecutor, who is lying to all of us. I'll explain. Who spent 27 years in the county previously, and we're gonna see why he. Yeah. Anyways, during the tenure of Prosecutor Dennis Well, Tony Cillo was the chief of the criminal division, and in that capacity, he was supposed to lead a cadre of young prosecutors, teaching them the finer points of prosecuting a criminal case, including when to go to trial, how to win, and when to negotiate the case to obtain a guilty plea. Tony Cillo didn't do any of that. He didn't teach and he didn't lead. As one assistant put it to me, quotes, when you walked into Tony's office with a question, it seemed that his objective was to facilitate your exit with as much dispatch as possible. Because Cillo couldn't or wouldn't teach or lead these lawyers, Assistant Prosecutor David Mahek was appointed as the criminal division chief. When I was elected, I appointed Attorney Chris Pierre as the chief of the criminal division of prosecutors, and as well chief of the major trial division. Attorney Pierre has brought the integrity to the prosecutor's office that Tony Cillo only talks about. Criminal cases that had sat on desks throughout Cillo's tenure as criminal division chief were actually being prosecuted. Police officers were no longer treated as though they were incompetent, but rather were encouraged to bring their cases to the office. That's good. Police officers were no longer treated as though they were incompetent, but rather were encouraged to bring their cases to the office. If their cases were ready for grand jury consideration, we indicted and prosecuted. If they weren't ready for the indictment, our prosecutors worked with the investigating police agencies to make the cases better. More glaringly than Tony Cillo's failure in leadership is the prosecutor's office was his capacity for sloth. While he was the criminal division chief, he let 150 felony indictments go unserved. The result was that these defendants were never arrested or prosecuted or otherwise held accountable. Worse, justice was denied to each of these victims. Under Division Chief Chris Pierre, each of these unserved indictments was 1, reviewed, 2, evaluated to determine whether the defendant could be located, and 3, analyzed to determine whether the evidence was still viable. The police agencies that brought these cases helped us by locating and serving defendants with their indictments and were able to move forward. Now, all of these cases have been resolved. When I began my term as county prosecutor in 2021, I designated Tony Cillo and his perennial co-counsel, Lorain County, as the major trial division. This is the section of the office charged with trying the most serious of our cases. In the 1.5 years that Tony Cillo quotation worked in the major trial division of my office, he was the highest paid assistant prosecutor we employed. Nevertheless, during the above 1.5 year period, Tony Cillo appeared in only 13 cases and went to trial in only one case where no verdict was reached. The defendants in 4 other cases pled guilty, so he pleaded out 4. In another case, the defendant died, so then one dead. So you got, let's see, 13 cases, 1 went to trial, so that's 6. So 6 out of 13. Cillo's remaining 8 cases were finished by other assistant prosecutors after he left. Thus, I have I'm trying again. Almost done. I have discovered the origin of the nickname given to Tony Cillo by former administrative assistant Anne Marie Victor, quotes, the one file wonder. It was Tony Cillo who taught me the post-COVID concept of an employee engaging in what is called quiet quitting. This is where instead of leaving his employment, the employee remains in his job and continues being paid his salary. He just doesn't do much work. That was Tony Cillo. 6. In part 6 of your letter, you imply that one or more of my employees... Oh, wait. Am I reading this again? Oh, no. I'm not. No, I'm not. Okay, sorry. One or more of my employees were paid without working. Because your employees tend to talk about their investigations with others, I have been made aware that the employee you reference as not earning her pay is Jennifer Battistelli. Please note that Ms. Battistelli believes this criticism of her is directly attributable to Tony Cillo. Indeed, according to Ms. Battistelli, when she was employed in this office, she was forced to remove the extra chair in her cubicle due to the inordinate amount of time that Tony Cillo spent sitting in it. She claims that after failing to respond to his attempts to get to know her better, he ignored her and began defaming her to others, even to the extent that her attorney was compelled to serve Cillo with a demand that he cease and desist. Ms. Battistelli believes that his animus toward her is what drives him in his attacks on me. In the above regard, I am advised that Ms. Battistelli's counsel have conducted an audit of her time working at the prosecutor's office. I am further advised that this is the same counsel are prepared to meet your allegations with a defamation suit if you were to publish your suspicion regarding her lack of work. So wait, I don't read that again. I am further advised that the same counsel are prepared to meet your allegations with a defamation suit if you were to publish your suspicions regarding her lack of work. Below is my account. In 2020, after I was elected to office of prosecutor, I offered Jennifer Battistelli a position of community outreach coordinator. She brought with her years of experience in high-end retail sales. I believed by applying solid principles of marketing to our outreach efforts, the prosecutor's office could develop a brand, a reputation in the community for being enthusiastic, accessible, helpful, and credible. Ms. Battistelli's performance. Jennifer Battistelli scheduled meetings for me with local mayors, police chiefs, township officials, county agency directors, nonprofit service providers, senior citizens groups, veterans groups, and labor organizations. I met with public school children and their teachers. Miss Battistelli attended many of these meetings as well to assist me. For the time in the history of the prosecutor's office, job descriptions were prepared for each position in the office. A job description was prepared for the position of community outreach coordinator. Some of the functions in her job description that Miss Battistelli performed in exemplary fashion were the following: acts as a strategic advisor to the county prosecutor to determine and prioritize community outreach strategies. Responsible for recommending, organizing, planning, and implementing community events and meetings for the county prosecutor in consultation with the chief of staff. Responsible for marketing of events, including consulting with outside vendors, obtaining estimates, and reviewing and approving copy for promotional materials. Acts of a liaison between the county prosecutor and other elected and appointed government officials. Represents the interests of the county prosecutor's office at community events and other meetings in the prosecutor's absence. Accompanies the prosecutor to community events and governmental meetings upon request, and plans, organizes, and or implements employee recognition and office team building events. Compensation. Three more pages, y'all. Compensation. Ms. Battistelli's compensation was determined after reviewing compensation packages provided to employees working in a similar capacity in other counties. We had 3 specialized administrative positions in the office when Jennifer Battistelli was here: Chief Financial Officer Special Accounts, and Ms. Battistelli's position, Community Outreach Coordinator. All 3 positions were unclassified, exempt, and each requires a special skill or knowledge in order to excel in their specific capacities. One of these employees had been granted an accommodation, i.e., she is permitted to work 1 day per week remotely. All 3 of the above positions were paid equally, and the employees received pay raises at the same time. Ms. Battistelli, working both in and out of the office, earned her salary. 7. In item 7 of your letter, you list the various offices that you have engaged to conduct your investigation of my office. As expressed to you in my letter of April 4th, 2024, delivered herewith, I will be contacting one of these agencies in the immediate future. I am familiar, however, with your investigation, and the conduct of your employee, Captain Robert Vansant, has continually attempted to contact Jennifer Battistelli by insisting that, as an employee of my office, she was abused and exploited by me. As expressed above, I have personally seen Vansant's text messages to Ms. Battistelli, and is clearly a predator. Though Ms. Battistelli has repeatedly told Vansant that my relationship with her was not combative or exploitative, he continues to allege it, notwithstanding that he has continued attempting to pursue a personal relationship with her. I am confident that an examination of Vansant's telephone history, forensic or otherwise, would furnish each of us with enough information to conduct an investigation right in your own office. Both Vansant and Tony Cillo have contacted women I date and have dated solely for the purpose of attempting to pry some report from them that alleges I gotta read that again. Both Vansant and Tony Cillo have contacted the women I date and have dated solely for the purpose of attempting to pry some report from them that alleges abuse or some other scandalous behavior on my part. As set forth above, they have gone as far as contacting Jen Battistelli's former hairdresser, Alicia Quinn, again for the purpose of attempting to wrestle some fictitious tale of infamy regarding my treatment of women. Cillo, however, has not stopped. He recently sent a Facebook message to the woman I am currently dating, chastising her for associating with me. I do not believe that you would characterize this type of pandering as law enforcement. I feel certain you were unaware at that time that any of the foregoing nonsense was occurring in your office. Call me. Respectfully, J.D. Tomlinson, Lorain County Prosecutor. Oh, did I say it? Did I say it? Did I say it? I said it. I said it. I said it. Thank you again to whoever shoved that in my mailbox today. And I wish I had like a Ring camera or something that I could be like, it was this person. But, you know, I also have journalistic integrity, and I will always, if you don't want to be named and you want to give me something or provide me with a document, I will never disclose who you are. People should be comfortable to openly approach me and give me whatever documentation you want. I am not on anybody's team. You can't put me in a camp. I'm a little on the fray like that. But, you know, as we discussed, it just kind of fits today. As we discussed earlier, you know, that was one of my biggest things was, you know, you're accusing and putting all in the paper a man of abusing his ex-girlfriend over a 60-second, 3 60-second videos that have absolutely no context. You don't know what they're talking about. You don't know who they're talking about. You don't know why they're talking about it. But what I said again, you know, the one that really, you know, touched a nerve with me after getting over, you know, the yelling, just the language and the yelling, just because people react to just that alone. I listened to what the man said, and he said, "What is wrong? I'm not comfortable. I'm not comfortable being around. I'm not going. I'm not comfortable." And that just like, it triggered me. It made me think like, well, what could he not be comfortable about? People don't just like go like, I'm not comfortable. I'm not, you know, going. So it means you don't want to. She's trying to me, and this is my theory, is she was trying to bring him around somebody that he was not comfortable being around. And he was pretty much straight up telling her, this isn't going to happen. I'm not doing it. Why are you, the person that I'm supposed to be in a relationship with, putting me in a situation that I've told you multiple times I'm not comfortable with? And then again, I'm going to get back to, you know, we as a society have a problem sometimes, not all the time, but a lot of the times, you know, really quick to accuse men of abuse. And you know what's even worse is that this was brought up by other men. So you have other men accusing this man, knowing it could ruin his entire career, it could ruin his life, of beating and abusing, well, not beating, but abusing, maybe beating because they've insinuated it, his ex-girlfriend, who was a crazy bitch trying to get a payday from the county. I mean, look at her accentuation on, you know, her spousal support. Apparently, the bitch is worried about money. You know what I mean? And unfortunately, you know, we might have had to pay $100,000, but he also replaced it in his budget by getting rid of her. You know what I mean? And it could have cost the county taxpayers millions. Because what of course that came back is he didn't pursue it. He said, you know, you can sue us. They pursued the lawsuit. Of course, it then doesn't pay whatever the lawsuit is, which is our insurance. So have a premium. That will come out of the county's money. Then the county would have to pay the $1 million lawsuit to this chick who falsely claimed, but just because, you know, she fits that narrative, she fits that picture, and the jury would probably go, oh, you know, like, she got lucky with the $100,000 payout. And I think she's now going again after the $350,000 because she don't have no money. People think $100,000 is a lot of money. It very quickly, it's not. It goes quick when you just get, you know, it goes quick. And I think my theory, my guess, is that Mrs. Battistelli kind of set JD up here a little bit. And when JD didn't play ball with Michelle and Harry, when they tried to blackmail him over getting involved in the CCI thing, with the and I'm not gonna call it anymore, with the tape of his mom, two adults doing what adults do, and Harry, confiding in Michelle about it. Fucking, that was hilarious. I lost my shit earlier. I was like, it was just funny reading it, like this guy acting like I confided in her about a blowjob I received. It was just dramatic. Like, and then the fact that Michelle even says in the sheriff's report, she didn't say it once, but she said it twice. Now we have the county prosecutor finally coming out and saying Vansant, this guy who's supposed to be doing this investigation, for one, isn't investigating the radio controversy or a contract. He's investigating Commissioner Moore and Commissioner Riddell for rescinding the contract on behalf of the safety forces of Lorain County. And then, well, safety force, I don't want to say safety forces in general. I would say safety force leadership as in associations and political bull. You know what I mean? And then you got Cillo giving out 100 grand bars, talking about this chick that the prosecutor is dating, and Tony Cillo has engaged in some kind of inappropriate, uncomfortable, and maybe not inappropriate, uncomfortable behavior towards her himself, and even to the point where he received a cease and desist letter stating, "Leave her alone." Tony Cillo was running as a Republican, who is a never Republican. I'm not even saying never Trump, never Republican. He's never been a Republican. He pulled a ticket so he could specifically run against whoever was running next, which was more the probability of it being JD Tomlinson was high, so it was JD. The FBI showing up, claimed FBI, showing up to Jennifer Battistelli's hairdresser. The fact that Captain Vansant was texting, Battistelli, regardless, they're adults, whatever. I don't really care. And married people do what married people do, and divorce, single, whatever. I don't really care what adults do. I don't care what adults do. What I care about is Vansant has been investigating our elected officials, and again, another elected official, JD Tomlinson, on behalf of some political retribution, retaliatory behavior, defaming our elected official, regardless of who it is, and we're paying his salary to do so. He could be putting that effort towards a more appropriate investigation, let's just say, not elected people for political purposes and lobbying on behalf of private vendors for your own whatever bullshit gain. And Vansant, there's a line there. I mean, there's a line here, and the fact that you see this this door trying to trap JD into being painted as a man that abuses women, working as a prosecutor, even though the woman he's accused of abusing has a history of domestic issues. Just in 2019, it wasn't 10 years ago, it was 2019. So me, kind of, yeah, no, I don't think so. And, us as women sometimes need to be able to say to other women that clearly, are using that victim card, which I hate because it's a slap in the face to any real victim of domestic violence. Any woman that the prosecutor's office is representing against an abuser, a real abuser that really does some damages, and physical, emotionally, and not just some narcissist that's worried about her, and some election. Because as much as she says that in these texts, like to his mom, like, I care about your son. Bullshit. If you cared about her son, why would you be sending, why would you be courting him in the first place? Why would you putting me in situations that he's uncomfortable in, apparently? Why would you be, just the question itself can ruin somebody. So us as women have to sometimes do the right thing and speak up for men on behalf of men and be like, you can't just say he fucking hit me based on a recording where the camera was pointing at your leg the whole time and you shook. So people are just like, oh, he hit her. Did you see his hand go like this? Did you see his hand go like that? No. And when he spoke to her, like, we shouldn't put our hands on each other, should we? He was trying to get her to admit that she accosted him. That's what I do to my 5-year-old. We don't do that, do we? We don't throw trash on the ground. We pick up trash, right? Right? I didn't pick up the trash. That's what he was doing to her because she's an idiot. Apparently likes to put her hands on people when she's upset. Because apparently I think she got too big for her britches. I think she went in there and thought she was something. And when he wasn't like, you're just not going to just do whatever the hell you want, little Miss Jennifer got upset and then was like, I'm going to sue you and I'm going to find a reason to do it, even though her reasons were unsubstantiated. And even though, with all the recordings that were released and everything, she's never said a word publicly. And no offense, it wasn't about a sexual relationship that she claims in that little document that was posted regarding her allegations, because after she said it was because she ended a sexual relationship, she then continued the sexual relationship. Make it make sense. Do I like the fact that the $100,000 was paid? No. But you know what I do like? I like that the $100,000 was paid rather than $3-4 million, because he didn't settle the suit and he was going to take it to court. I like that he thought of Corsa and thought of our insurance premiums going up and being in our history. I like the fact that happened. I like the fact that Dan Petticourt and him, got together and said, this is going to be an issue. We put her on a stand. What is the jury going to say? And there's a ton of factors that go into that. Not just, if he's innocent, he's innocent. No, that's not a thing. That's not a thing. I could bring up a million things. And again, a vote for Tony Cillo, right now, it's a vote for Tony Cillo as a Democrat. So you're voting for the same and that's been going on for the last 30 years in Lorain County's prosecutor's office and Lorain County's criminal division, or you stick with somebody who's already in there now, who's new, but has made some good changes and is trying to bring that office together and has really stayed out of this bullshit. He has STFU'd all day. He has just gone mute, hasn't said anything. I'm not getting involved. And they tried to blackmail him with the sex tape of his mother blowing somebody. The only reason that tape wasn't released is because they couldn't, because it would directly go right to them as blackmail. Even in the sheriff's report said it, unless they're blackmailing him. And no offense, you don't allow yourself to be blackmailed. You're just blackmailed. You don't know, hey, I'm going to let you guys, take a videotape of my adult mother doing, whatever adults do with whatever is her, that's none of our business. And I'm going to let you threaten me with it. And then really what he did is called her bluff. He's like, yeah, go ahead. You've told me once, Michelle, and you're telling me twice, go ahead and do what you need to do. I can't get involved here. It's inappropriate. And then I think my theory, just inkling here, and I'm pretty good at this. Jennifer was working with Hong a little bit, and she was recording JD strategically to eventually set him up. And there you have it. Whoever sent me this, thank you so much. I'm sorry, I got to string you along for another day. Tomorrow night, because I got stuff to do during the day tomorrow. It's my school days. We're going to finish this up, and I'm going to, provide you with a letter that you can send to the Attorney General. Also the FBI in Cleveland. I'm requesting proper investigation. If the FBI has time to go around, knock on people's doors asking about this Vansant investigation, they have time to actually do some actual fucking work and look at the documents that I sent. I'm sending certified to them. Usually I go to the post office, but we need to we need to wake up, Lorain County, and we need to stay focused. So stay focused. I'll see you tomorrow. Grace and hustle. You gotta give hustle and gotta have grace. Again, thank you. And you couldn't make this stuff up. It's crazy. I'll see you tomorrow, you guys. Have a good night. Thanks. Thank you for joining me today on Mean Street. I hope you enjoyed the show. I would greatly appreciate it if you would consider supporting our work and supporting my effort. You can support directly underneath at the Spotify donations, or you can directly give a donation at paypal.me/Mean Street, Ohio. Any donation received will help me continue to provide news to you and everyone else across Ohio and beyond. I love what I do, and I just hope to continue to do it. Thank you so much, and you have a wonderful day. Thank you for joining me today on Mean Street.